Hi, I'm Nancy Sohnpan. We're excited to be here this morning at the beginning of AALS for our section program for the Family and Juvenile Law section. We have some great speakers lined up this morning. We're going to follow this structure. We're going to see 4 different presentations in sequence, and we're going to take a break in the middle, and then at the end for some question and answer. Our topic today really developed out of a discussion of all the different ways that people experience family law and all the different ways people define family law that may be different from traditional views of both how family law works and the scope of family law. So we're going to start off today with Richard Storrow. Richard is a professor at CUNY. He teaches family law, wills, trusts and estates, and property, and his research focuses on reproductive justice, wills, and immigration. After Richard, we are going to hear from Jessica Feinberg. Jessica is an expert in family law and gender and sexuality law. She's a professor at the University of Maine. She joined the University of Maine after teaching at Mercer Law School for 9 years, and she teaches a variety of courses as well. Our third speaker is going to be Jill Hastay. Jill is the Distinguished McKnight University Professor and Centennial Professor of Law at the University of Minnesota. She teaches and writes about anti-discrimination law, con law, family law, and legal history. She's written 2 books, one of which is the basis for some of her remarks today. And our final speaker is actually 2 speakers from Rutgers. We have Ann Friedman, who teaches a variety of family law-related courses, works with a clinic on child support, has written books, has taught at a variety of law schools, and is joined by her colleague, Victoria Chase. Victoria directs the Domestic Violence Clinic, serves as chair for the Camden Clinical Program, and has worked extensively and hands-on with a number of clients in a number of situations. So those are our 4 speaker groups today. Each speaker is going to have about 13 minutes, and then we're going to leave plenty of time for questions. The first questions after Richard and Jessica, and then the second questions after Jill, Ann, and Victoria. So we will get started here, and I turn it over to our first speaker, Richard Storrow.
Good morning, and thank you so much. I'm really honored to be serving on this panel, and I want to thank the section, Nancy, and all of the other officers for organizing this event. Family law is not normally thought of as a system in which you can opt in or opt out. But one of the classic opt-ins that we're all familiar with is the Lair Doctrine, which gives an unwed father of a child born to an unmarried woman a certain amount of control based on his behavior vis-a-vis the child over whether he can object to the child's being adopted by someone else, typically the mother's new spouse. And I'm interested in whether and really how this option, this opt-in, applies to a known provider of sperm to an unmarried woman. So in general, sperm donors are not legal fathers by statute. And for now, I'm simply going to assume that a categorical bar like that is not consistent with the Lair opt-in. And so if it's not constitutionally permissible to categorically bar sperm donors in that manner, then the question becomes, how close can we come to locking the sperm donor out? How early in the process of creating a child can we do that before we collide with this opt-in that's provided by constitutional family law? So the Lair Doctrine, as you recall, is a synthesis of several cases going back to the 1970s on unwed fathers and their rights to paternity. And this line of cases refutes this theory of paternity that would be based solely on biological connection alone. It emphasizes behavior-based commitment to parenthood. And this opportunity that Lair gives is an opportunity to prevent an adoption from going forward. The test is articulated this way. The unwed father must demonstrate a full commitment to the responsibilities of parenthood by coming forward to participate in the rearing of his child. This has become known popularly as the biology plus test. So if unwed father has done the plus, he can object to the adoption by withholding consent. And if he has not done the plus, the adoption may proceed, even in the absence of what would otherwise be required, a full hearing on the unwed father's fitness. So the question then is, what set of facts is going to be adequate for showing this full commitment? The Supreme Court test is notoriously vague. The court has left it to the states to work it out, and really has said nothing more about the substance of that test since it made the decision in Lair in 1983. So we can look at what states have done in their laboratories around this doctrine. And I'll mention just a couple here, New York and Illinois. New York has embodied this Lair doctrine in a statute, basically suggesting that an unwed father of a child of less than 6 months needs to have shown certain things in order to block an adoption. Illinois has done something similar. The statutes have come under constitutional attack, specifically in New York, where the requirement was that the unwed father have lived with the mother. And the Court of Appeals decided that with respect to a child of less than 6 months, that requirement wasn't adequate for satisfying Lair, which really emphasizes the connection between the father and the child, and not so much between the father and the mother. So that provision was declared unconstitutional. The Illinois statute and the New York statute line up pretty well, apart from that requirement, in suggesting that some of the factors that courts will look to are whether the father has openly held himself out as the child's father, whether the child has lived with the child, and certainly for a child of older than 6 months, whether the father has provided support, visitation, communication, emotional support, and so forth. And then, of course, for a very young child that's being placed for adoption at birth, courts have found it permissible to judge the father's behavior during the pregnancy. Was he supportive of the mother in ways we would expect of one prepared to take on the responsibility of parenthood? One specific piece of evidence of this would be contribution to pregnancy and later birth expenses. The Lair doctrine is also salient in the Indian Child Welfare Act, which requires that the unwed father have had custody of the child. So let's turn to cases involving sperm donors. These cases are different from the typical Lair case, which involves an adoption petition. So first of all, these sperm provider cases are not adoption cases. No one is trying to displace a biological father with someone else in these cases. And second, the child would not have been born without the sperm donor's willing participation in the project of creating the child. And finally, there's almost never any sexual relationship. I can think of only one case where there had been an ongoing sexual relationship that was then ended, and then the sperm donation occurred. So the first question we could ask is Lair even relevant here? My work is done by courts who have said yes, so I'm just going to assume that it does. And this is true even in cases where children will wind up with only one legal parent. After all, our artificial insemination laws were crafted in part to enable single women to parent alone or with their partners. And courts are saying that the same questions that Lair asks in the typical unwed father case involving an adoption is the same. What is the plus that's required in a sperm donor case? And specifically, can we move the time frame within which we're going to judge the sperm donor's behavior to a point in time prior to conception? So a couple of things come out of these cases. First of all, the donor has to be a known donor. Anonymous donors don't get any layer protection because they've already shown their disinterest in remaining anonymous. Second, it would be enough if the donor entered into an agreement with the biological mother that he would be the child's legal father. And this is true even in a state where there is a categorical definition of all donors as not fathers. So that's a direct application of the Lair doctrine. And other states have opted to make this opt-in explicit. So they're going to require a written agreement with the mother if the donor is to have any parental rights, even if that, practically speaking, has to happen prior to conception, which is the point in time at which the sperm donor can opt in or opt out. So obviously, this is a very clean approach to Lair questions. Either there's a written agreement or there's not. And on the question of whether that complies with Lair, a Kansas court, in which we do have one of these opt-in statutes, reasoned that since the bar was not a categorical bar, that Lair was satisfied. It gave the sperm donor an opt-in, and either it was seized or it was not. So is one step short of an absolute bar, which is what this is, adequate? And I want to say there are a couple different ways we could approach this question. One is that this contract model is attractive because it's efficient, right? It contemplates a specific point in time. Our fact questions are answered at that specific point in time, and we move on. But we could take the position that that is actually too far prior in time to what Lair is really asking us to look at. And that's because Lair itself uses language such as emotional bonds and reasonable efforts to perform as a father, or doing all he could have done under the circumstances. And a couple of decisions involving assisted reproduction, specifically egg donor cases, have resonated with this notion that even the provider of gametes, just like any unwed father, has an inchoate right to a reasonable amount of time to come forward and behave as a parent. So this is this broad construction of Lair that would be inclusive and favorable to later claims of paternity brought by sperm donors. But the problem with these decisions that I'm referring to is they really, first of all, they involve the categorical denial statutes, right? So there's already a tension in cases like that. And second, they also involve cases involving gestational mothers who are having children with their same-sex partners. The partner is donating the eggs. So their planning and preparing to conceive and raise a child together is salient from point A all the way up to point B. And they don't tell us much about the typical sperm provider case, and even less about whether a statute like Kansas's that does give the sperm provider an opportunity, albeit limited, is enough to satisfy Lair. So the other avenue of analysis is one that posits that a written agreement is compliant with Lair because it fits really nicely the context of unwed mothers who employ artificial insemination. First of all, they wouldn't procreate without an assurance that the sperm donor isn't going to assert paternity. It's also very sensible in the typical case where a woman is asking a friend to help her procreate and become a single mother. And there's all of this planning going on preconception, which is distinct from the typical unwed father case. So this analysis would define the Lair doctrine's opportunity interest for sperm donors as more limited, requiring the man to express his desire for paternity early. And for a couple of reasons, it would be consistent with Lair's language. After all, Lair talks about things that are beyond the unwed father's control. this would not be a situation that would be beyond a sperm donor's control to accomplish. And interestingly enough, it would be consistent with the facts of Lair. Lair was a case where the court found that there was a special statutory scheme in New York, the putative father registry, and the fact that the unwed father, post-birth, of course, had not taken time to register with the putative father registry meant that he had not adequately seized his opportunity to be a father. So that's what we're looking at in a sperm donor case like the one in Kansas, where we do have the opt-in. It is at an earlier point in time, but it is a special statutory scheme set up to reflect the specific circumstances of sperm donors and should be adequately consistent with Lair. So other fathers as well, just like sperm providers who will lose their opportunity early in time, have also lost their opportunity. Men who are not sperm donors, but whose child is being placed for adoption right at birth, have also lost their opportunity interest because of a failure to do what's adequate after the pregnancy is known, to contribute to pregnancy medical expenses and afterwards birth expenses. So it absolutely is not without precedent, even in a world prior to a lot of artificial insemination, that the opportunity interest is something that has to be grasped early, even when the child is not conceived by assisted reproduction. Thank you so much.
Thank you, Richard. That was a great presentation, and I'm saying that in part because I want to encourage everyone watching to use the chat function to submit any questions that they want to pose to you and to any of our other speakers. We're in the weird situation where we can't see anyone attending and don't know how many of you are out there, but I've been assured there are a lot. So use your chat function, and then I will be speaking your questions for you. After we've heard from Jessica, we'll have the first set of questions. So Jessica, take it away.
Right. Good morning and Happy New Year. I'm really happy to be speaking on this panel. So my article addresses the potential of extending non-adoptive marriage-based parentage establishment avenues to male same-sex couples. I decided to write about this because I found that as I was proposing methods of creating more equitable parentage establishment for same-sex couples in previous articles, I kept having to drop footnotes saying that the proposals wouldn't apply to cisgender male same-sex couples because so much of parentage establishment stems from the person who gave birth. So in this article, I took the opportunity to begin to address an issue I had put aside for too long. And I started with marriage-based parentage because of the stark way that these avenues are now benefiting certain categories of same-sex couples, namely those in which one of the parties gives birth, and then wholly excluding others. So historically, when a same-sex couple was raising a child who was genetically connected to one member of the couple, establishing parentage for the other member was difficult. Since non-adoptive avenues of establishing parentage generally stem from either actual or perceived genetic connections to the child or marriage to the individual who gave birth, for most of the nation's history, these avenues were unavailable to the non-biological parent. Adoption represented the only avenue of establishing parentage, and its availability differed widely by jurisdiction. With the nationwide legalization of same-sex marriage, however, female same-sex couples and other same-sex couples in which one member is able to gestate the child have gained increasing access to non-adoptive marriage-based avenues of establishing parentage. These avenues provide a presumption of legal parentage to the spouse of the individual who gave birth. So the common marriage-based avenues of establishing parentage include the marital presumption and spousal consent to assisted reproduction laws. Historically, the marital presumption provided a rebuttable presumption of parentage to the husband of a woman who conceived or gave birth to a child during the marriage. Spousal consent to assisted reproduction laws generally have provided a conclusive presumption of parentage to a husband who consents to his wife's use of assisted reproduction with the intent to be the resulting child's parent. The extension of these marriage-based parentage establishment avenues to female same-sex couples has been relatively straightforward. For female same-sex couples, it's fairly common for one of the spouses to give birth to the child. As a result, states have been able to extend laws providing marriage-based avenues to female same-sex couples simply by adopting gender-neutral language to refer to the person who's deemed a parent on the basis of their marriage to the individual who gave birth. Cisgender male same-sex couples, however, continue to be excluded from marriage-based avenues of establishing parentage. Cisgender male same-sex couples who wish to have a child who's genetically related to one member of the couple require the help of a surrogate to gestate and give birth to the child. In the vast majority of cases, the couple will utilize gestational surrogacy, in which the surrogate gives birth to a child who was conceived using ova from a third-party donor and sperm from one member of the couple. Because marriage-based avenues of establishing parentage provide parentage on the basis of an individual's marriage to the person who gave birth, as opposed to an individual's marriage to a child's biological parent, male same-sex couples who conceive children via surrogacy are unable to use marriage-based avenues to establish parentage. Furthermore, only a minority of states have surrogacy laws that recognize both members of a male same-sex couple as legal parents when the child is conceived in this manner. As a result, in most states, while the member of a married male same-sex couple whose sperm was used to conceive the child, the biological intended parent, often may obtain parentage through existing paternity establishment procedures, his spouse, the non-biological intended parent, must pursue adoption in order to establish legal parentage. Now, excluding male same-sex couples from marriage-based parentage establishment is problematic for a number of reasons. Adoption is, of course, often an expensive, lengthy, and invasive process. And importantly, until the adoption is completed, the non-biological intended parent is not a legal parent. This leaves both the child and the non-biological intended parent without essential rights and protections and in a state of uncertainty. This exclusion also sends the harmful message that families headed by male same-sex couples are inferior and less deserving of legal recognition than families headed by different sex couples or female same-sex couples. So the continuing exclusion of male same-sex couples from marriage-based parentage avenues likely stems from two major sources. One is the conclusive presumption of legal parentage that generally attaches to an individual based upon the act of giving birth. And two, the pervasive gender-based stereotypes and beliefs about caretaking and parenting that continue to linger today. So first, if conclusive legal parentage attaches to the individual who gave birth, extending marriage-based parentage presumption to the spouse of the child's biological father would result in the establishment of legal parentage in at least three people simultaneously: the individual who gave birth, the biological father, and the biological father's spouse. This presents a significant problem since the vast majority of jurisdictions only recognize a maximum of two legal parents. In addition, providing individuals who give birth with a status, conclusive legal parentage, that generally can be voluntarily terminated only in specified narrow circumstances involving adoption proceedings, confines parentage establishment for male same-sex couples to the realm of adoption. Another significant barrier involves the longstanding societal beliefs that women should be primarily responsible for the domestic sphere and that women are more capable than men at caretaking and parenting. Throughout the years, the law has, of course, reflected and served to reinforce these gendered beliefs. These barriers, however, should not preclude the extension of marriage-based parentage establishment to male same-sex couples. The conclusive presumption of parentage based upon the act of giving birth is an outdated concept that fails to reflect the realities of modern medical technology and the diverse circumstances under which children are conceived today. Reform to make the legal parentage that attaches to an individual based upon the act of giving birth rebuttable in appropriate circumstances is long overdue. Moreover, the gendered stereotypes and expectation regarding parenting abilities are not only inaccurate, but also extremely harmful. Laws that challenge and dismantle the gendered stereotypes that continue to linger about familial roles will promote greater equality both in the workplace and in the home. So the article proposes that states adopt standards providing for the rebuttal and disestablishment of the presumed legal parentage of the individual who gave birth when the individual is not genetically related to the child and undertook conception in conjunction with the intended parents with the mutual intent and understanding that the intended parents would be the child's sole legal parents. The article further proposes that states amend their marriage-based avenues of establishing parentage such that these avenues extend to the spouse of the child's biological, legally recognized father upon the rebuttal and disestablishment of the presumed legal parentage of the individual who gave birth. While advancing inclusive surrogacy laws that recognize intended parents as legal parents is also an extremely important ongoing goal, many states, of course, still have not passed laws addressing surrogacy, and some states expressly prohibit the practice. So some states may find it easier or more palatable to facilitate parentage establishment for male same-sex couples by extending the long-standing avenues of establishing parentage that already exist, such as marriage-based avenues, as opposed to creating new avenues, such as surrogacy-based avenues. Just a few other things to note. So while the article focuses on establishing parentage for non-biological intended fathers, the proposal will also help non-biological intended mothers in the surrogacy context. When a married different-sex couple enters into a gestational surrogacy agreement in which the child is conceived using sperm from the intended father and donor ova, only a minority of jurisdictions recognize the intended mother as a legal parent. Consequently, today in most jurisdictions, while the husband, the intended father in this situation, can establish parentage through existing paternity establishment procedures, his wife, the intended mother, must pursue adoption procedures. At the same time, we're seeing this trend in cases where the surrogacy agreement is not recognized, but because the intended mother's ova were used to conceive the child, the court allows for the surrogate's parentage to be rebutted and disestablished, and the intended mother's parentage to be established by extending paternity disestablishment and establishment procedures to maternity determinations. In these cases, the surrogate's parentage can be rebutted only if the intended mother's genetic materials and not a third-party donors were used to conceive the child. This means that something as important as the surrogate's legal parentage hinges on whether the intended parents happen to require an egg donor to conceive, even though the surrogate's relationship to the child is exactly the same in either situation. So if there was an egg donor, the surrogate is conclusively deemed the child's legal parent. And in the vast majority of cases, that legal parentage is attaching against both the surrogate's wishes and the wishes of the intended parents. This result can then only be altered through adoption proceedings. Under the proposal, however, the surrogate's legal parentage is rebuttable based upon the lack of genetic ties to the child, together with the parties' mutual intent for the intended parents to be the sole legal parents. And upon rebuttal of the surrogate's parentage, the spouse of the child's biological legally recognized father, regardless of their gender and regardless of biological ties to the child, will be able to establish legal parentage through marriage-based avenues. As a result, the proposal will provide critical parentage rights for couples of any gender makeup who conceive children via surrogacy using sperm from one member of the couple and donor ova. Finally, by establishing a method for rebutting the parentage of the person who gives birth, this proposal would also open the door for the extension of non-marital avenues of establishing parentage, like voluntary acknowledgments of parentage, to male same-sex couples. This is important as my guess is that VAPs are the next method of parentage establishment that will become widely available to female same-sex couples, which has already occurred in several jurisdictions. Thank you.
Thanks, Jessica. This is the first of two breaks we'll take now for the opportunity for people to ask questions. If we don't get any questions now, we'll just have more time for questions at the end. I am monitoring the chat. Right now, I'm not seeing any questions, so I encourage anyone who has questions or comments for Professors Feinberg or Storrow to give them to us via chat. And if we don't get any, we will move on to our next presenters, unless our presenters have questions for each other.
I have a question for Richard.
Cool.
And my question, I just would like a clarification about the Kansas situation, because I got the idea that you were equating it to what's possible in Lair, that the New York statute allowed a unilateral method through the putative father registry. And I thought the Kansas statute had to do with an agreement with the mother. And so that made it sound like it wasn't unilateral. So I hope you could clarify that for me.
Yeah, no, I didn't mean to suggest that it was, but all I was suggesting was that the legislature had enacted statutes for these opportunities. One was the putative father registry, which, as you say, is unilateral. The other one was the enactment of the possibility for the sperm donor to enter into an agreement. So that would have to be bilateral. Absolutely correct.
So that seems to me that it would pose a constitutional problem. Potentially.
Yes, potentially. If we're thinking that Lair, it should be read more broadly and more inclusive of sperm donors that want to come forward and act as a father later. But then we collide with the policy behind artificial insemination statutes that allow single women to become single mothers. And the policy is to resolve the paternity question early.
Yeah, the reason I was asking the question is because I'm familiar with an old New Jersey case in which there's some, when people don't write agreements, there's some ambiguity about what the intention is at the beginning. And lots of people who use donated sperm from a known donor aren't well informed legally and don't have any agreements one way or another.
Yes.
And it's very efficient to say, well, unless you have a written agreement, you're out of luck. But it doesn't seem to me it takes account of the messy realities of what's actually going on the ground.
I completely agree. And I would say that there are messy realities of lack of information. There are also messy emotional realities. And I think that the problem that I have with the Kansas model is that it requires a writing.
Okay, other questions or comments amongst the panelists? We're still warming up on the chat function, I think, here. I haven't seen any questions yet. So I know at AALS, the typical structure is to wait till the end, but we wanted to try sprinkling the opportunities throughout in case you had questions for a specific panelist earlier. So seeing no chat questions and hearing no questions from our panelists, our third panelist is Jill Hastay. Jill?
Okay, thanks very much for including me. I'm delighted to be here. My talk today is based on my book, Family Law Reimagined. This book is about the dominant stories that judges, legislators, and commentators tell about family law. I argue that these stories often misdescribe the field, misdirect the attention of legal decision makers, and misguide the policy choices they make. In a nutshell, the punchline of my book is that much of the common sense about family law actually makes little sense. For purposes of today's discussion, I want to focus on three important aspects of family law that are often excluded from dominant narratives: the exclusion of federal family law, the exclusion of family relationships beyond marriage and parenthood, and the exclusion of the family law of the poor. So I'll start with the exclusion of federal family law. One dominant story about family law contends that it is inherently local and not a matter for the federal government, even though federal law governs virtually every other area of life. The Supreme Court likes to make pronouncements along these lines almost every chance it gets. For instance, the court has repeatedly declared that, quote, the whole subject of the domestic relations of husband and wife, parent and child, belongs to the laws of the states and not to the laws of the United States. The tone of these pronouncements often implies that their correctness is self-evident. More than just declarations, the idea that family law is inherently and exclusively local has powerfully shaped family law. The narrative hasn't actually prevented the development of abundant federal family law, but the Supreme Court has relied on the premise that family law belongs exclusively to the states to structure decision-making about both family law and many other subjects. Many other courts, judges, legislators, along with advocates and scholars, have similarly drawn on the idea of family law's localism to impose congressional bills and statutes on the ground they constitute federal family law and are inappropriate for that reason alone. For instance, the 1996 Violence Against Women Act created a federal civil right to be free from gender-motivated violence. In my view, this statute wasn't a federal example of federal family law at all. It didn't regulate the creation or dissolution of legally recognized family relationships, and it didn't determine rights and responsibilities tied to family status. The remedy was available to victims of gender-motivated violence without regard to whether there was a family relationship between victim and perpetrator. But opponents of the civil rights remedy called the remedy federal family law and condemned it for that reason alone. The Conference of Chief Justices, the Judicial Conference of the United States, and Chief Justice Rehnquist never challenged the Act's substantive goal of combating violence against women, but all of these groups lobbied against the civil rights remedy on the ground that it was a form of federal family law, and family law is not federal in nature. Similarly, when the Supreme Court ultimately struck down the civil rights remedy in VAWA in the Morrison case in 2000, the idea of federal law is inherently local also ran through that opinion. A very different group of decision makers and critics opposed the 1996 Defense of Marriage Act, or DOMA, which defined marriages for federal purposes to exclude same-sex couples. But here, too, a major argument that dissenting legislators and critics advanced against the act insisted on family law's localism and condemned DOMA on the ground that it was federal family law. Despite such declarations, state family law coexists with extensive and important federal family law. Myriad federal statutes, regulations, and decisions govern the creation and dissolution of legally recognized family relationships and or determine legal rights and responsibilities tied to family status. I discussed the existence and extent of federal family law in the book. Here, I'll just give 3 quick examples. For example, federal law provides that a couple can be married for purposes of state law, but unmarried for purposes of federal immigration law if the couple married just to help a non-citizen obtain U.S. citizenship. Federal law provides that a couple can be unmarried for purposes of state law, but married for purposes of federal Social Security law if one member of the couple had a good faith but mistaken belief that they were married under state law. Federal law regulates adoption, child custody, and parental rights in tremendous detail. In sum, the oft-repeated idea that family law is inherently and exclusively local simply misdescribes and obscures the field. The question of whether the federal government can or should regulate family law has long been settled as a matter of actual practice. The existence and extent of federal family law makes clear that a federal law cannot be logically undermined simply by identifying it as a form of family law. Instead, judges and legislators need to evaluate each proposed or existing example of federal law on its individual substantive merits and to consider which level or levels of government is best situated to carry out that particular policy. For example, in my view, the case for a federal civil rights remedy against gender-motivated violence is substantial. Enforcing equal protection guarantees is a core federal responsibility. Moreover, Congress had amassed compelling evidence that state laws against domestic violence, rape, and other gender-motivated violence were under-enforced, inadequate, and or enforced in ways that were discriminatory according to the state's own gender-biased task forces. In contrast, the Defense of Marriage Act was a terrible idea on the merits. But the problem with the statute wasn't that it was an example of federal family law. It was that it discriminated based on sexual orientation. I'll turn now to my second example of exclusion, the exclusion of family relationships beyond marriage and parenthood. Family law focuses tightly on marriage, parenthood, and sometimes their functional equivalents, such as cohabitation between non-marital sexual partners or de facto parenthood. Legal decision makers regularly take this aspect of family law to be so commonsensical as to require no explicit acknowledgement or defense. For instance, one recent book designed to introduce law students to family law begins by observing, quote, "In its traditional sense, family law involves the legal relationships between husband and wife and parent and child as a social, political, and economic unit. In recent years, the boundaries of family law have grown to encompass legal relationships among persons who live together but are not married, so-called non-traditional families. As this description of the field suggests, family law devotes remarkably little attention to considering how to regulate or protect relationships other than marriage, parenthood, and their equivalents. Yet siblings, grandparents, grandchildren, uncles, aunts, nieces, nephews, cousins, and other non-canonical relatives can also be central to family life and to the flourishing of family members. Family law's reflexive orientation around marriage, parenthood, and their equivalents diverts attention and scrutiny from considering how the law should regulate and protect other family relationships. For example, the sibling relationship is a crucial yet non-canonical family tie. Siblings have the potential to be extraordinarily significant in each other's lives, providing intimacy, support, love, joy, connectedness, care, and caregiving. Despite the potential importance and value of sibling bonds, however, sibling relationships have attracted remarkably little attention from the law. Family law views children almost exclusively through the lens of their relationships with their parents, rather than the lens of children's relationships with their other siblings. The law offers siblings only modest and sporadic protection, too often permitting adoption or parental divorce or death to separate siblings and sometimes leave them with no right to connect with each other or even to know of each other's existence. Siblings can be vital sources of nurturing and stability for children, and family law could do more to threaten sibling bonds when they're threatened. In my book, I use the example of sibling ties to examine the law's treatment of non-canonical relationships and to consider some of the reform possibilities that emerge to explore and debate when we free ourselves from the assumption that family law should only revolve around marriage, parenthood, and their equivalents. I'll turn now to my third and final example of exclusion, the poor's absence from dominant stories about family law. Family law's canonical narratives do not touch on poverty, yet much of welfare law is also family law as well, determining crucial rights and responsibilities tied to family status. The exclusion of welfare law from official accounts of family law has helped judges and lawmakers avoid acknowledging and discussing why the legal regulation of poor families is so different from the legal regulation of other families. The family law governing the poor is premised on inspection interference, where the family law governing other families generally stresses the government's interest in protecting privacy and reducing intrusion, even when distributing financial benefits. For example, my book explores the contrast between Social Security, which is generally not associated with poor families, and Temporary Assistance for Needy Families, or TANF, the most prominent federal state welfare program. Both Social Security and TANF provide redistributive benefits to family members whose primary wage earner is dead, incapacitated, or not working. Yet Social Security is organized around norms respecting privacy and autonomy that generally govern family law, while TANF reflects the investigatory, instrumental, and interventionist premises common in regulating poor families. Recognizing that policies now classified exclusively as welfare law can simultaneously be family law brings the divide in how family law regulates poor families and other families into clear view. It reveals the starkly divergent treatment of poor families as a practice that courts and legislatures need to explain and justify or eliminate. My book concludes by reflecting on the path to reforming dominant ideas about family law. Changing what I call family law's canon, its dominant way of understanding itself, is difficult by definition. The very concept of a canonical idea is that it is an entrenched, widely shared, oft-repeated way of thinking about a subject. Legislators, regulators, judges, lawyers, scholars, and family members transmit canons intergenerationally, teaching new generations to think along the lines their predecessors do. Moreover, legal officials have the most control over the canon, and their power to wield the force of law makes it easier for them to resist outside scrutiny and critique. The content of a literary canon is largely within the hands of academics who decide what they'll teach, what they'll write about, and what constitutes exemplary work. In contrast, the content of a legal canon is mainly in the dominion of legal authorities. They wield the most power to decide both what the law is and what counts as a convincing argument in a courtroom or legislative hall. Their decisions, statutes, and regulations have the force of law, even if some scholars, lawyers, litigants, or individual citizens disagree with them. The specific hurdles associated with altering what lawmakers and jurists think and do suggest that an effort to reshape dominant ideas about family law will be most successful if the effort begins with law schools and the process by which they transmit canons and ideas about family law to students, lawyers, and legal decision makers. In other words, the best way to start changing how lawmakers, judges, and citizens think about family law is to change how we teach family law. Of course, family law courses should still cover the field's traditional areas of interest: marriage, divorce, child custody, child support, and adoption. But I think it's also important that students emerge from their family law courses aware of the existence and importance of federal family law, the family law governing the poor, and the law governing relationships beyond marriage and parenthood. I look forward to your questions and comments. Thanks for your time.
Thanks so much, Jill. We're working with a technical issue. I understand there are audience comments in chat, and we're working to get them available to us because I'm sure there are a lot of questions after your wonderful presentation. So right now we're going to transition to Victoria and Anne while we are working to make the comments available so that I can convey them to all of you. So Victoria and Anne, it's your turn.
Hi, everyone. Thank you very much. My colleague, Anne Friedman, and I are excited to be here and presenting today. So thank you for having us. We will be discussing lessons learned about family law experiences of low-income parents through our child support and reentry clinic, and how similar practice-based activism is needed to grapple with on-the-ground family law realities. Systemic forces trap litigants and prevent them from seeking positive changes in their lives. Some forces constraining litigants are obvious and some surprising. An obvious constraining force is the harshness and rigidity of child support law. Another familiar notion we confirmed is that negative dominant narratives can be both false and difficult to dislodge. The new lesson we experienced concerned constraints imposed by access to justice measures deployed to manage heavy family court dockets with large numbers of self-represented litigants. The hyper-simplicity of packet practice, as we call it, diminishes client options, induces waiver of rights, and permits courts to ignore complexity of client matters in favor of pre-packaged, rapid case processing. We're going to have three components of our talk today. The first is we're going to describe our course a bit and talk about a few of its unique features. We're then going to talk a bit about the complex interplay of dominant and realistic narratives that reveal systemic injustice in our work. And then finally, we're going to talk a bit about access to justice reform measures as a constraining force contributing to systematic injustice. Okay, so we decided to create a clinical and skills-based experience using our shared family law background that would make structural oppression in family and criminal law vivid and demonstrate the urgency for reform. Child support, particularly for reentering citizens, was the most dramatic example we could find. The clinic solidified our understanding of how family courts and associated administrative systems intersect to enforce and enact exclusion, social control, and surveillance. The dynamics of systems often evade our pedagogical efforts. So getting proximate, to borrow Brian Stevenson's notion, requires on-the-ground experience with law in action. So we had several takeaways in our work. One was that student self-development is a helpful preparation for when students are engaging with clients and displaying empathy as a means to establish relationship. Another takeaway from our work was the value of working with client narratives and pleadings as an overlooked pedagogy in family law. A third takeaway we had was that client experiences can offer really significant insights, new light for looking at aspects of family law and family law pedagogy. We also had opportunities to explore the destructive power of the moral construction of poverty and how that elevates the married family form in ways that disregard poor litigants' lived realities and can have devastating consequences. Finally, we really experienced the shadow side of access to justice in hypersimplification of matters that were proceeding along the FD docket, the what we call the non-dissolution docket in New Jersey, and that this oversimplification tended to trap clients and lock them out of certain forms of relief. So, what was our course like? Well, our course was a novel course in the sense that it was targeted to an intermediate stage of development and intended to both advance exposure to interviewing and counseling skills, narrative, pleading practice, and drafting. Student narratives and meta-narratives about family law, dominant narratives that inform the creation of laws and obscure client lives, were an explicit area of inquiry in the course that we created. And we encourage students to be not only in the zone of their own narrative exploration of what it means to be a lawyer, but also the narrative of the laws that were enforced, as well as the narratives of the client. Our course began with an intensive interviewing and counseling unit with a skilled actor teacher in the role of the client. And the skilled actor teacher was able to do things like provide on-the-spot feedback and encourage students in experimenting with techniques while in role. And then we moved into a second phase of the course, and this is where the clinical phase happened. And there we conducted a unit where we were providing advice and counsel for returning citizens on their child support matters, and then drafting paperwork to support them in proceeding before the court. So who were our clients? Well, our clients were predominantly Black males returning after state court sentences. Occasionally, they had intermittent criminal justice involvement over an extended period of years, but frequently their sentences were below 10 years. They were living in custodial and transitional settings or sober living facilities targeted at the reentry population. They had usually either high arrears or a high weekly order, or occasionally both. And when we interviewed them, what we found was that they uniformly had extremely complex life circumstances, resources, and needs that they were seeking to meet as they were returning. So, despite the fact that child support can be susceptible to a notion that it's simple, right? That it's the product of a mathematical formula. We can have a guideline. You can just apply it. It's a simple outcome. What we found was that, in fact, the client matters were extremely complex, far more complex than I think either one of us had anticipated before we began teaching this course 3 years ago. In the first instance, we found that collateral consequences such as driver's license issues and interstate custodial issues were common and extremely hard to resolve with clients. We also found that child custody, child protection, and domestic violence often intersected in our client histories, and that this made it difficult for them to proactively address their child support matters. We also found that the child support system would fail to grapple with multiple family obligations, which were in fact pervasive. And then in addition to those sort of structural issues around the claims themselves, we found that there were circumstances that affected our clients that made it very difficult for them to engage in, trusting and productive relationships with their lawyers. First, profound process failures abounded. And I mean process failures that were caused by the court system prior to, really without any connection to lawyer involvement. And also those sorts of experiences that they'd had perhaps with lawyers in their histories that had made them distrustful. And so clients frequently expressed surprise that help was available, and it was available without some sort of string attached to it. And they also tended to grow in their engagement with services over time as trust also grew. Anne, can you? So normally we're switching here.
Yes, I have to unmute. That was
very
the challenge. Good. Running the slides and unmuting. This is too much for me. So one of the things that was important for the class was for the students and for us to grapple with the dominant racialized child support meta-narratives, which underlie our child support system. And it's very important, given Jill's talk, to point out that these meta-narratives are largely driven by federal law at this point, although state law has had to comply with federal law, which is not to say the states would go their own way without it, but the federal government has played a very big role in these narratives. And I think these narratives will be quite familiar to people who have worked on the issue of unmarried fathers and child support. And low-income families are typically locked into either a dominant support narrative of deadbeat dads who could easily find work and pay the order if only they were responsible, and destitute mothers thrust into dependence on state aid. And then there's a simplistic counter narrative, more positive narrative, supposedly, that casts the obligors and poor families as helpless victims of an unjust system. So we wanted also to look at the harsh automatic enforcement that is that these attitudes support. And so people appreciate how harsh and rigid the child support system is. Family law survey courses often provide a narrative of progress when child support is taught, from a past of uncollectible child support and fathers crossing state lines and not paying for their child support, to federal enforcement measures that make sure obligors pay. This progress narrative, along with the dominant narratives about child support that we've already discussed, obscure the way harsh enforcement measures dominate the lives of low-income families. Just to highlight a few of the toxic mixture of enforcement measures that are listed on the slide: rigid confiscatory guideline amounts for low-income obligors quickly aggregate and can't be retroactively modified. Mandatory driver's license suspension prevents clients from working and often leads to burgeoning fines and fees for driving without a license. Arrest or incarceration until the purge amount is paid is a common enforcement measure, which disrupts stable lives, creates criminal histories for some obligors who don't already have such histories, discourages obligors from going to court to straighten things out, and provides another basis for negative police encounters. So we worked with our students intensively on narrative, and our goal was for them to stay open to cues from the clients amid the play of narrative. So they needed to be aware of the dominant narratives that we were trying to counteract for our clients. They needed to be aware of the possibility of positive stock counter narratives having to do with the unfairness of the system. And particularly last spring, when COVID first hit, we wrote a lot of certifications using the counter narrative, because the fact that clients were unemployed was more forgivable at that moment than it would be in other circumstances. But we particularly wanted them to pay attention to telling details in client stories. The certifications, we found that certifications can be extremely powerful stories. And this slide sums up the types of certifications our students were able to create because they were attending to the telling details. In 3 semesters, we were particularly struck by the frequent examples of client agency around their children. These acts of these formerly incarcerated dads were inconsistent with dominant narratives about serial parenthood as an irresponsible family form. And we also frequently found less adversity, in fact, sometimes cooperation between obligors and custodial mothers, which is not part of the conventional child support narrative. Now we're going to turn to the third element of our talk, the negative effects of certain access to justice reforms. The narratives that our students wrote for our clients would never have been available to our clients without legal assistance. And that barrier of the lack of access to lawyers is fairly familiar to people. Although, as Jill points out, we don't pay much attention to that impact because we don't pay much attention to poor people. We pay more attention to people who have lawyers. But in addition, these are some other familiar barriers that lock people out of family court assistance. Public benefits requirements, in which TANF allows states to file child support proceedings and control those child support proceedings regardless of what the family wants. Hidden legal norms and limited community knowledge of accurate legal information, and court processes that shape perceptions of legal options. So this last idea about court processes, before we did this course, we really didn't understand how powerfully the court was constraining narratives that were available to clients and remedies. So, like many states, New Jersey has faced an increasing rate of self-representation, particularly in family court, as well as heavy caseloads and inadequate funding. Unfortunately, the reforms that New Jersey judges crafted in response to this crisis were shaped by a series of harmful beliefs. Because poverty and unmarried parenthood are readily construed as moral failures, and self-represented litigants are more likely to be low income and unmarried, it seemed logical to the judges to simplify procedures for all unmarried litigants and then rationalize the resulting disparate treatment of unmarried litigants in comparison with married litigants or divorcing litigants on the basis that unmarried litigants' family law cases are uncomplicated and hence suitable for standardized summary processing. Basically, if you have a property dispute or you have a big custody battle with experts, that's complicated. But the family law of poor unmarried people, that's very simple. So access to justice and case law management concerns were simultaneously resolved by a convenient pretense that low-income families' legal needs are somehow less urgent or complex than other family court litigants' needs.
So we thought we'd close with a few additional observations about this packet practice that we encountered in our work in New Jersey and that we suspect is present in other jurisdictions as well. And in packet practice, this packet, which is publicized by the court and people sometimes fill out by hand, replaces the typical motion practice, which would be associated with dissolution cases. And by standardizing both the litigant's communication and then the universe of possibilities of judicial orders in a check-the-box format, the packet really deprives litigants of accurate legal information as well as an opportunity to communicate effectively about their matters with the court. So our packet practice occurs in several different ways in New Jersey. However, the docket that we're concerned with here is a docket for non-married litigants with child custody and support matters. And we wanted to point out a few things that are true about these matters and about the practice that the packet not only encourages, but also enforces. And that is that there's no right to discovery, no response to pleadings. They're treated as summary dispositions by courts unless a judge intervenes. And there's a motion for complex treatment by an attorney who might join the case. And complex treatment isn't even listed as an option. To wrap up, while self-represented litigants might have an opportunity to appear before the court, they have little opportunity to gather information, craft papers that relate to their circumstances, present their arguments, or ask questions. And there's several different things wrong that affect specifically returning citizens, which we've placed in the slide. So our time is up, so we're going to close up. We just wanted to note that this type of practice-based activism is that we think a replicable model for change, right? Getting proximate is a way to, and is a necessary way probably to understand state variations and critical local knowledge that tell us about systemic injustice, that tell us what's really going on beyond the surface of what we see from casebook pedagogy. Thank you very much. You're muted.
All right, I'm muted because we were trying to find our questions and comments, and we have now found our questions and comments. So we will segue into that portion of the session. So we first have a comment that Kansas's putative father registry has no teeth at all. It's an Excel spreadsheet maintained by a clerk. A letter goes out saying that registration has no legal effect and potential adopters have no duty to search it. I have my students call to see about how to register each year as a class exercise. And I think that then kind of segues into a question that goes to Jessica and Richard's presentations. And it says, might the solution require a new constitutional standard for parenthood? For example, an update to the Lair standard to account for all the changes to the family that have happened since the 1980s.
Well, I'll just jump in and say, yeah, I fully agree with that. I mean, Lair seems very outdated. Back in 1983, we weren't talking a lot about these assisted reproduction matters, and not at all thinking about the time frame within which these activities needed to occur. It was always post-birth. So we're really engaging in an experiment that I think needs more guidance. It is time for the Supreme Court to revisit Lair and clarify it.
Although the membership of the court may not be ideal for that project.
Bracketing that concern, yes.
Okay, the next question says, Jill, I am writing an article about my mother's family experience in the foster care system. Her oldest brother petitioned to open a closed adoption so that their youngest sister could learn about and meet her 9 siblings. In your research, did you find any state laws that allowed for siblings to have standing to establish a relationship with one another?
Yeah, look at the, I have all the statutes cited in the book, so you should pull the sibling chapter and you'll find all the statutes. What's interesting, I mean, I think there's a few things. The typical tragedy, and well, there's so many tragedies, but one standard sibling tragedy in foster care is they don't have a good enough system if one sibling goes into foster care, they don't have a good enough system for getting a subsequently available sibling with the first one. So then the siblings end up placed in different homes, not because someone said, I can't handle another one, but because they didn't get the opportunity and they develop parental ties and then there's an obstacle. A few states have, I have all the statutes cited in the book, but the states range from make efforts to very little. Realistically, you need just this, if you're a minor child, you need the support of your parent. It continues to be the case that a lot of foster care systems still even have a right of contact or access or et cetera. I mean, if you have both parents that are both foster parents or eventually adoptive parents who are excited about it, it can happen, but it's very, I think it's very undeveloped, the idea that siblings might have a claim to connect with each other, at least once they're majority. One of my I have a lot of proposals in the book, but one of my many proposals is thinking more about sibling registries. Right now, registries are very organized around the idea of biological parents connecting, like after adoption, which, yeah, good, right, that's all good. But I think they could also be more systematic about the idea of siblings. One thing that surprised me that I didn't really think about before I wrote the book is that a number of people who had either been placed for adoption or in the foster care system actually reported that they were more interested in connecting with their siblings, in part because they had issues with there was abandonment, they had thoughts about their parents, but they had only good feelings about their siblings. And that seemed like to them a fresh start. So I really think it is something that the state should do more of. And that's exactly, and the last thing I'll just say is, I think how best to regulate siblings and especially how to deal with potential conflicts between parent-child relationships and siblings is super complicated. And it's not like I think my answer is the only answer, but I just think that's exactly what we need to talk about. Like, it's not like siblings is going to be just snap your fingers. It's going to be just as complicated as all these other relationships, but I just want to put it on the table. It's not just parent-child, in my view, or marriage or marriage equivalent. Siblings is also really important, or can be a really important bond for people.
Okay, we only have a couple of minutes left then. In those couple of minutes, if each of you could suggest one discrete addition to kind of a standard intro to family law course related to your presentation, what would that one discrete piece of information or exercise or idea be?
Should we go in the order we presented it?
Sure, that sounds great. So Richard, you're up first, then Jessica, then Jill, then Victoria and Ann. One specific suggestion for a takeaway to add to a family law course.
Yeah, unfortunately, my topic is sort of lifted from family law casebooks. So I think I'm going to refer to Victoria and Ann and say that I feel that is a really rich and fertile area that you're exploring that could have the potential to really upend a lot of our approaches to family law, if not the substance that we're focusing on.
One thing that I've been thinking about a lot, and as I'm writing my next article, is this idea of, from where the second parent should stem, right? We have this kind of system in place where the person who gives birth is kind of parent zero, right? And we figure out who the second parent is a lot of the time, right, from that first parent, that person who gave birth. And so, thinking about, is that the way that things should work? Is that the only way things can work? And having an exercise along those lines, I think would be an interesting thing to do in class. Thanks.
Cool.
I have a ton of ideas about this. One thing I think it's really important for students to understand how family law overlaps with so many other subjects. So you can't cover every aspect of family law. There's a lot, but just to have a sense that there is family law in the tax code. There is family law in the immigration code, just to like a teaser. So that's something they think about when they go to other classes. I think that's just a really important idea that family law is pervasive. That's another way of making the federal family law point. Some federal family law is really just like kind of family law, but a lot of it is overlapping with other areas. It's tax, it's immigration, et cetera. So I think that's really important. I think making them aware of the family law governing the poor, how much of the casebook is really about middle-class families. So just highlighting that a lot of it is really, you have to have a certain level of money and access to lawyers for a lot of family law presumptions to apply and that don't apply. And then I'm really passionate about the siblings idea. I know you can't do an entire family law course about non-canonical relatives, but I really think it is worth at least one class noting that so much of family law is around these canonical relationships of marriage and its equivalents, or parenthood and there's equivalents. And there's all these other relationships the law has relatively little to say about. And I think that's like the first step to get people to think about it.
Okay. Victoria and Ann, one specific takeaway. We're pretty much out of time. So you
want to go, Ann? All right. So Ann and I spent a fair amount of time talking about this. I've had the chance to teach family law only once. Ann has taught it many, many times. And we talk all the time about how to bring not just the family law of the poor forward, but also the family law of the vast majority of people we still call middle class, who still can't really afford an attorney very easily. And so figuring out ways to get our students in a mindset about how different family laws affect them specifically, what it might look like if it were to be, applied in their family, what might happen if they were experiencing, some sort of dissolution issue, like getting them in a mindset of recognizing how rare it is to have a family that is actually of the type of income, which is often described in the casebooks. So yes, our course is a way of doing it. And then Ann has really built some amazing strategies around bringing exactly this type of material that we've been developing into her casebook course.
Well, I know in my course, sometimes we sit down and draft out a budget because my students are appalled that, fathers aren't paying child support until we look at the income and subtract out the cost of living. Suddenly they get it a little bit better. So we're out of time now. So thank you to all of our panelists. I'm sure you hear lots of virtual clapping. There have already been some comments on great presentation, and thank you. And for everyone who's out there watching, the Family and Juvenile Law section has a networking session next. So if you want to go back to your program and re-log in, you can hang out and chat with lots of people, including, I would guess, at least some of our panelists, and talk more about family law. But thank you so much for participating. And, I hope next year we get to see each other in person. Thank you, everyone.
Thank you.
Thank you.